Hi, everyone. We have people coming into the room. We're going to give it a couple more minutes before we get started. While we are waiting, if you want to introduce yourself in the chat, feel free to. I'm Katie Zimmerman. I'm a librarian with the MIT Libraries. And we'll give it a few more minutes as people come in. Hi, everyone. We're just giving it a few more minutes while people join. Okay, I'll go ahead and get started. I think we've hit saturation point on people joining the meeting. So welcome. Happy New Year, everybody. It's January 4th, 2023. And welcome to this webinar. So I think this is the first session in the Intellectual Property Speaker Series. So we're going to talk about fair use. We're going to talk about copyright. Yes, please introduce yourself in the chat if you are so inclined to do so. We're going to have an interesting discussion about a very interesting topic and using creative stuff. Before I jump right into that, we do have a bunch of other sessions in the series coming up. These QR codes will take you to the lists of them, and I encourage you to sign up for anything that looks interesting. I'm also dropping a link in the chat if you prefer to view the slides in your browser instead of the share screen. Then that is an option for you there. Okay, so this, the slides, that is the link to the slides on the slides. If you prefer to view it in HTML view, that's sometimes useful to folks. That is how you do that. Please do engage in the chat, say hello, comment, ask questions. I will try and keep track of the questions in the chat. If I miss something, remind me. You are welcome to want this to be a conversation. Want to make sure we're talking about the things you want to talk about. Please do try and keep yourself muted if you're not talking. We've got a bunch of folks in here, so that'll cut down on background noise. And with that, I will go ahead and get started. So we're talking about copyright today. This is the Intellectual Property Speaker Series. There are multiple types of intellectual property. Today, I am specifically talking about copyright. So I'm not talking about patent. I'm also not talking about trademark. There is a fair use doctrine in both copyright and trademark. They're a little bit different. What I'm talking about specifically today is copyright fair use. So what does copyright cover? Copyright covers original works of authorship. It covers creative works that are recorded in some sort of tangible form. So this is a pretty broad category. It's kind of also an ever expanding category. But it includes roughly these categories of things: literary works, which is basically text, which is, the written word. That also includes software that's written down, that gets considered a literary work for these purposes. Musical works, dramatic works, plays, musicals, theater, choreographic works, dance, pictorial, graphic, and sculptural works, photos, art, sculpture, visual art, motion pictures, movies, other audiovisual works, video games, sound recordings, architectural works, and this is an illustrative list, not an exclusive list. So it can also include other things if they end up being considered an original work of authorship. So that's what we're talking about. We're not talking about inventions and patentable processes. We're not talking about trademarks, but within the scope of copyright, the scope of copyright is pretty broad. So for copyrightable things, that is what we're talking about. So then what does copyright cover for those things? For those things, copyright gets the copyright holder a certain set of rights related to their property. When you create something, you get a copyright in it. You don't have to do anything in order to get that copyright. You don't have to register it. You don't have to put a notice on it. Registering it, you can register it, and that has certain benefits, but copyright exists natively under in our legal system. Copyright exists natively as soon as you create something. So when you create something, what rights does that get you? That gets you the right to reproduction, the right to copy it. That's the copying part of copyright. The right to modification, so the right to modify it, to adapt it, to create a screenplay out of your novel, to adapt it to a new medium, to translate it into a new language, the right to distribute it, so to sell copies, to give copies away, to lend copies, the right to share it broadly, and then the right to share it with the public in the form of public performance or display. So showing the movie, showing the play, hanging up the artwork in a gallery, those sorts of rights. So it's a very broad set of rights. Why does this exist? It's worth thinking about that. Intellectual property applies to what are called in economics non-excludable goods. So things where if I give you an apple, I no longer have that apple. If I make a copy of a book and give you the copy of the book, I still have the original copy of the book. And that makes intellectual property, things that are covered by copyright, difficult to control economically. And the idea here is we want people to create copyrighted works. We want books and movies and art to exist in the world. And we want people to be able to make a living from doing that. So we create a legal regime that allows people to make money from their works by allowing them to exclude others from their works legally. So that's the ultimate rationale for why we're putting all these rules around what you can and can't do with intellectual property. But the balance of that is this is a very broad set of rights, and you don't want to have to ask permission for absolutely everything. That's bad for free speech. That's bad for commentary. That's bad for, so there has to be a counterbalance against it. And that's actually what we're going to be focusing on today, which is the counterbalance under US copyright law, which is called fair use. I see we have a question. Will the recording be shared with attendees afterward? I believe it will. Okay. Okay, so if we think about copyright, let's pause for a second and think about all the ways that you interact with copyrighted materials in your everyday life. It is probably more than you really think, and it happens all the time. So if you're writing something and you quote someone, that's copying someone's copyrightable expression. You're copying their work. You're quoting it, you're attributing it appropriately, you're doing everything you should be, but you are using their copyrighted work. Similarly, if you're on social media and you share a photo that someone else took, that's a public display and a distribution of someone else's copyrighted material. That doesn't mean it's a copyright infringement. That we're not all flagrant copyright infringers all the time, and the reason for that is fair use, which we're going to talk about today. So what is fair use? Fair use is our counterbalance against the rights of the rights holder. This is the right that you as a user and consumer and reuser of works have to make additional uses of things that other people have created. So this is originally a judge-made doctrine. It was developed by judges who were trying to interpret this fairly, and then it became incorporated into the statute the statute for copyright law in the United States. It's worth noting that this isn't the way that it's done everywhere in the world. There are lots of countries that take a different approach. They take kind of an enumerated list approach of saying, here are all the things that you can do. Research, okay. Text mining, okay. And they give you a specific list of things that you can do with other people's copyrighted work without getting permission. That's not the approach we have in the United States. Instead, what we have is fair use, which is, it's both a little bit more frustrating and more flexible. So it's frustrating because you don't have a nice little checklist of I'm in this category, therefore I'm fine. You do have to kind of think through this intellectual exercise of, is my use a fair use? But it's nice because it's flexible and it can apply to new circumstances. Is it a fair use to ingest a whole corpus of textual material in order for your machine learning algorithm to be trained on it? Is that a fair use? That might be a fair use as opposed to having to wait for Congress to decide whether they're going to add it to the list or not. So it's a different approach. It's the approach we have here. So the language of fair use, this is kind of the prelude to it. The fair use of a copyrighted work for purposes such as criticism, comment, news reporting, teaching, multiple copies for classroom use, scholarship, or research is not an infringement of copyright. So we've got kind of a little summary built in there of the kinds of things that we're kind of thinking about for fair use. But the actual core of the analysis is a 4-factor test. And what the law is trying to get at here is really, it's actually right there in the name. It is trying to get at what is fair. What is something that we don't actually want to require people to have to go get permission for. We want this to be okay. Everyone kind of agrees it's okay. Maybe some are closer to the line than others. But we think that this should be fair for you to not need permission, not need to go pay a fee in order to do this. And then because just saying the word fair is a little bit vague, then we get this more structure that's built around this to help us determine whether it's fair. Let me just look at what's going on in the chat. Okay, we will have some time at the end to get to some of the more specific questions. So let's start by going through the 4-factor test. So the 4-factor test, this is kind of my summary of it to make it a little bit more understandable. You can go look at the statute for the actual language, but this is kind of the core of it. The first factor under the 4-factor test is the purpose and character of your use. What are you doing with it? Is the thing that you're doing something that that the law doesn't want you to have to get permission for? The second factor is the nature of the thing you're using. Copyright is more protective of some sorts of things than others. Some things are closer to the core of copyright, and we want to protect those a little bit more, so that factors into the fair use analysis. The amount taken, are you using the whole thing? Are you using an appropriate amount? That comes into it. You sometimes see fair use kind of shortcutted around the amount. You'll hear a rule of thumb of less than 10 seconds or less than a paragraph or something like that. That's actually not that's not quite right. That's an oversimplification. It's one factor that factors into it, but it's not the end of the story. And then the fourth factor is the market effect of fair use. What is the economic impact of you using it in relation to what the original creator is doing with it? So let's look at each of these in a little bit more detail. So for the first factor, we're looking at the purpose and character of your use. What are you doing with this thing? Is what you're doing fair? So there are some things that help with this. These are kind of the things that are mentioned in the prelude earlier. So if it's a non-commercial use, you're not making money from it, that helps. If it's educational, scholarship, research, news reporting, commentary, those things all help, but they're not the end of the story. What the first factor analysis has really started to focus on in recent years is your use transformative? So kind of, are you using this as a building block? Are you using it in order to do something new and different with it? Or are you just kind of replicating what the original creator did with it? And the language around this is, does it add something new with a further purpose or a different character, altering the first with new expression, meaning, or message? So if you're doing something new, if you're doing something innovative, that's much more likely to be a fair use, as opposed to just kind of doing the same thing that the original person was doing. So that language comes from a specific court case. This comes from the Campbell v. Acuff Rose case, which you may also see referred to as the Two Live Crew case. So this is a case between Roy Orbison and Two Live Crew, they're both musical groups. And it's over two songs that are both called Pretty Woman. So let me see if this will play. I hope it will. So just to get a sense of it, this is the Roy Orbison song. Are you guys getting audio?
I'm not getting audio.
Okay, let me fix that. I think I need to stop sharing and reshare. Sorry about that. Okay, now it should work. Okay, so that's kind of a sampling of that. It's kind of you likely have heard that song in some capacity or other. It's got a kind of classic Americana sort of vibe. So that's that. And then later in the 90s, I think, the Two Live Crew decides they want to do a version of this song. And their version is a little bit different. I'm going to play a clip of it. This is, in fact, the clean version of the album. I'm going to start. Okay, so it's clearly the same song to some extent, right? It's got the same tune. It's got similar lyrics. It's a play on the lyrics. The words are quite similar. Two Live Crew, when they were planning to do this song, they actually first approached the Roy Orbison estate, or the successors in interest to Roy Orbison, to ask for permission to do this, and the estate, or I'm not entirely sure who specifically it was, but they actually said no. So they approached, they wanted to license this song to make a new version of it, do it in a different way. The Orbison estate said, no, actually, we don't like your song. we don't want you to do this. We're not going to license it. Okay. They decide to do it anyway. And instead of doing it on a permission basis, instead of licensing it, they decide that they're going to make a fair use argument for this. So what does that look like? Oops. There we go. This gets us one of the classic Supreme Court cases about fair use. And the court says that yes, actually, this is a fair use. This is where we get the doctrine for the first factor. The court says that Two Live Crew is actually transforming the work. This is a parody, that it's not just repackaging the original. They're commenting on it. They're kind of commenting on the glossing over of what's going on under the surface in this song. They're commenting on the naivete. And then we also get this doctrine that the more transformative the new work, the less is the significance of the other factors. So they credit that this is they credit that this is a transformative use, that this is using it in a new way and commenting on the original. So that is, and that's kind of that's what you should be thinking about for the first fair use factor. Okay, so the second factor is the nature of the work that you are using. So the nature of the thing. And copyright is more protective of some things than others. Some things are closer to the core of copyright, and those are less likely to be a basis for fair use. Things that help in a fair use analysis, if it is a highly factual work, that helps in making the argument that it's fair use. Facts are not protected by copyright. You can have expression around facts, but that depending on what it looks like, it could be what's called kind of a thin copyright. So highly factual works more likely to be fairly used. There's also an element of this that comes in of how publicly available is the thing. So if it's kind of been released into the world, then it's more available for fair use than if it's a private, unpublished, someone's unpublished letter or something like that. Which again doesn't mean that if it's not published that it's completely unavailable to fair use, but this factor is going to weigh more heavily against it. With all of that said, there are a huge number of cases that say, and the second factor, we don't really care that much. So I'm not going to talk too much more about the second factor. It comes in sometimes, but it's a holistic analysis, and more often than not, it ends up not being the decisive factor in the analysis. Okay, so the third factor is the amount of the use, and the amount that you're taking from the original work that you're using. And the amount should be appropriate. And what does appropriate mean? Appropriate means that it's proportionate to the transformative purpose. So if you need to use the whole thing, you can use the whole thing. And we can think about the Roy Orbison example for this one. They are kind of using the whole song, right? They're using the melody, they're using the lyrics, they're using the bass line, they're using pretty much every aspect of the original music, but they need to do that in order to successfully parody it. It's not a successful parody if you can't recognize what it's parodying. So the amount they're taking is a lot, but it's proportionate to the transformative purpose, so it's still a fair use. With that said, less is generally better. You can think about this. A good example for thinking about this is if you're making a fair use case for using an image, you might need, if you're discussing nuances of color in an art photograph or something like that, then you probably need a high definition contrast color showing image of that. But if you're not talking about the color, if you're talking about something else, then maybe a black and white photo would suit your purpose, would allow you to make the commentary that you're making on this photo, whatever it is. So if you don't need it for the transformative purpose, then you can kind of bolster your fair use analysis by using less of the original. Okay, so that's the third factor. The fourth factor is the market effect of your use. This is where the economics kind of come in very explicitly. And kind of the core of this factor is, are people going to buy your thing instead of their thing? So if we go back to the Roy Orbison example, probably people who are buying 2 Live Crew CDs are not the same people who are buying Roy Orbison CDs, right? And probably you're not going to buy the 2 Live Crew. And even if you are, you're probably not going to be buying the 2 Live Crew CD instead of buying the Roy Orbison CD. These are different markets. These are probably not, that's probably not the sort of market harm that copyright cares about in that case. There may be some market harm. It's possible that 2 Live Crew is going to make people realize, like, you know what, that is a silly song. We agree. This isn't good music. We don't want to listen to this anymore. That actually is not the type of market harm that matters under the fourth factor, though. If you change public opinion, great. That's what discourse is. That's what we want to happen in society. But if you're just substituting for the original, then that's not going to be considered fair. So some things that go into this: is there a market available where you could have easily gotten permission? Could you have gotten permission and you just decided not to? That's perhaps going to weigh against your fair use analysis. There are plenty of cases on the flip side of that where it would be very, very difficult to get permission. Roy Orbison's estate is an entity that you can track down and negotiate with. There are plenty of copyrighted works that it would be impossible to even know who holds the copyright to them, right? So that's a phenomenon called orphan works. So that would be a case where there wouldn't readily be a market available, and that can help your fair use analysis here. And then it looks at both at existing markets, but also at likely markets. So just because the original rights holder hasn't moved into an expected market, that doesn't really get you off the hook. If it's likely that there would be merchandising associated with a movie, then because that merchandising doesn't exist yet, doesn't necessarily help under this factor. So likely markets also count for this factor. Okay, so then you weigh it all up. You weigh it all up together. All the factors are not equal. You cannot put this into a mathematical formula. I've said that the second factor tends to factor a little bit less. The first and fourth factor tends to factor a little bit more heavily. But all the factors weigh in together, and you have to do it on a case-by-case analysis. So it's very fact-based, which does not mean it's not predictable. It just means it's holistic. So you weigh it all together, and you come up with whether something is a fair use or not. And the other thing you should do when thinking about whether something that you're trying to do is a fair use or not is look for analogies. So fair use is ultimately determined by the courts. None of us really want to be sued and have to go to court to defend our fair use. But if you're making a fair use analysis, you want to have you want to be able to preempt that by saying, if we went to court, this would be the outcome. And courts give you nice long opinions of why this is a fair use and why this isn't. There are lots and lots of judicial opinions on fair use. This is a good tool for helping find them. Fair use can also be very different in different media. So so the Roy Orbison example is a music example that could be very different from the fair use analysis you'd see for a computer program, for example. So it can be helpful to think if you're trying to come up with a fair use analysis for something you're doing, it can be helpful to look at what courts have said about other similar things in the past. This is a useful tool for that. This is a database created by the US Copyright Office. It gives you just like a one-page summary of the case and the fair use analysis. You can filter it for various categories, and it's useful for coming up with this. Okay. So let's Let's dig into this a little bit more and let's look at some examples. So we're going to look at a few cases and then we're going to practice it and we're going to come up with a fair use analysis together. So our example for this, we're going to move from the music example. We're going to look at a couple of fair use examples. Or sorry, these are all fair use examples. We're going to move to some visual art examples. So our first example case here is Blanche v. Koons. So this is a photography case, visual arts case. The photographer here is Blanche, whose first name I'm blanking on. I think it's Andrea. Apologies, Miss Blanche, if I've gotten your name wrong. So the photographer here, she's created she does photography for advertisements. She's taken this photo, imagine this as a full-page glossy magazine ad. The ad is for the shoes, and she's created this image for this magazine ad. On the other side of it, we have Jeff Koons. He's a visual artist, and he created this work for an exhibit in the Guggenheim. It's kind of a visual collage of a lot of different things. I will say I'm not the biggest Jeff Koons fan, but he says this is art. Plenty of people agree with him. And it's clearly very different from the advertisement, but it does incorporate it. So here's the side-by-side. The feet from the Blanche photo are the second from the left in the Koons, and rotated and cut and combined with lots of other things. And then the question is this a fair use? So Koons did not pay for this. Blanche says, hey, you're using my stuff. What gives? You should pay me for this. Koons says no. He says it's a fair use. So which is it? So goes to the courts, and the court decision on this comes out as this is a fair use. So under the first factor, the court says that this favors fair use. They say it's a transformative satire of fashion magazines. Okay, it's kind of commenting on something. It's commenting on the frivolity of the original, something like that. The court credits it anyway as this being transformative satire. The second factor doesn't favor fair use. The original photo is a creative work. The court credits that. Even though it's an advertisement, sometimes courts don't like ads, but but it is a photo. It's a creative effort went into creating it. But the court says that doesn't really matter. This is one of those cases where the second factor doesn't really matter, given the transformative nature of the use. Okay, so then the third factor is the court says the amount is reasonable in light of the transformative purpose. He's using the part that he wants. He's not using the background. He's kind of transforming it a little bit. It's moved around. He's only using what he needs in order to make his point. And then under the fourth factor, the court says that this also favors fair use. They find that there isn't any market harm resulting from this use. And there's a little bit of factual evidence that goes into that. There's a little bit of looking at what was the licensing market for this photo and was that affected? It wasn't really. So the court says there's no market harm. No harm, no foul. It's transformative. It's a fair use. Okay, that's one example. Next example, same artist, different photographer. Similar set of facts. The photographer in this case is a man named Rogers. He has taken this photograph of a man and woman holding a bunch of puppies. He licenses it to some extent. I think it appears in some postcards, some things like that. Jeff Koons, same artist as the previous case, comes across one of these postcards and creates this artwork based off of it. So there's a shift in medium here. This is actually a sculpture. It's three-dimensional. I think it's about life size. It's pretty big. And clearly based on the photo. So here's the side by side, here's the photo, and Jeff Koons's sculpture. Okay, so is this one a fair use? Similar set of facts, different outcome. The court says that this one is not a fair use. So under the first factor, there's a couple of things going on here. One is that there's some evidence of bad faith, so that doesn't do you any good. That certainly doesn't help. There was some evidence that Koons had concealed the copyright information on the photo and was kind of trying to, there's a sense that he was trying to get around paying a customary fee, maybe. Not crediting it, which doesn't do him any favors here. That's maybe less important. It's also, it's credited as being a commercial use, which also doesn't do him any favors. That's arguably the same as in the previous work. They're both artworks. He makes a lot of money from selling his art. Both of those uses are pretty commercial. But in this case, because it doesn't have these other aspects, the court isn't buying it. And the most important thing is the court finds that there isn't really any commentary going on here. So in the Blanche v. Koons photo, he's doing different things with it. There's some physical transformation. He makes a successful case to the court that he is commenting on the sorts of source materials he's using. Here, the court says, you're not really doing anything different here. You just saw this photo and thought it was cool, and so you made a version of it. And that's not transformative. That's not a fair use. So that's what the court says under the first fair use factor. Under the second factor, similar analysis to the first. The original photo is creative, doesn't favor fair use, probably not, again, probably not determinative on its own, but it doesn't help. On the amount taken, they say that this also doesn't favor fair use, that he's copied the essence of the photograph, that he's kind of copied all of it without having that excuse of needing to for a purpose of commentary. So in the previous one, he copied some of it and it was deemed necessary for the transformative purpose. In this one, he's copied more and it's not in furtherance to a transformative purpose. And then under the fourth factor, the court also looks at some evidence and concludes that there is some market harm here, that people aren't going to be licensing this photo because now they're going to think of the Rogers sculpture instead. And overall, the court concludes that this is not a fair use. Okay, I'm going to pause there for questions. I see there have been a few. What does commentary mean in Rogers v. Koons? So what the court is getting at there is this concept of transformative use and whether the new work is making some sort of statement about the original work. So in the Roy Orbison case, they say that the new song is commenting on the original song. It's not just, hey, these are both catchy tunes and we're entertaining people. It's actually saying that there's social commentary going on. In this case, the court thinks that there isn't really any social commentary going on. I think, if I'm remembering correctly, Koons tried to make an argument that he was kind of commenting on the saccharine sweetness of the original photo and kind of making fun of these people for being so cute with these puppies. And the court didn't really buy that. The court found that kind of, it's still people being cute with puppies. The court didn't really buy his explanation. But the level of explanation that you have and whether or not that's important is actually fairly contentious. There have been some recent cases that have gone one way, and also that have gone others. Of how much explanation do you need to do about what you're trying to do here? Okay, let's see. Okay, so we have a question about the people in the photo. So that's a good thing to note. The couple, so that's not a copyright. That wouldn't be a copyright claim, is the first thing I will say about that. So the people in the photo might have a right of publicity claim or something like that there. They might be able to recover under a theory like that. But the people who are the subjects of the photograph don't have a copyright interest in the photograph, which is something that people don't necessarily realize. They might have, again, they might have kind of privacy or right of publicity sorts of claims that they could bring. But the copyright in the photo is held by the photographer, who's Rogers. So possibly, but beyond scope to some extent. Right, I'm gonna skip the Facebook question for now. We can come back to it at the end. How does the request for doing something transformative apply to educational use? So educational use comes into the first fair use factor. It comes into the analysis. It depends on what sort of educational use. So the fair use statute does say multiple copies for classroom use right in there. It actually doesn't fit super well with the transformativeness analysis that we've been talking about. It's a good thing to note. It's kind of an awkwardness of this when you're working with educational materials. But ways that it can be transformative, it kind of depends on what sort of educational use you're talking about. If it's a reading that you're distributing to class, then that's an area where we're not so much talking about transformativeness. We're talking more about the other fair use factors. If it's something like, but it can be transformative when it's something like, you know, you're commenting on you're in literature and you're commenting on a novel that exists. So you're writing about the novel, you need to quote from the novel in order to make your point about whatever point you're making about the novel. That would be a transformative use. Same with like art criticism and things like that. So there can be transformative aspects in educational uses. Some educational uses are not quite so strongly in this transformative vein. Which is a slightly incomplete answer, but that's what I can give right now. So, okay, how does copyright apply to publicly accessible archives for commercial, factual, creative works like documentary films? So if you're getting the thing from where you're getting a thing from doesn't matter to some extent. What matters is who holds the rights and what is the rights situation. So you can you can make fair use of something regardless of where you get it from. It's not really going to help your case if you get it illicitly, but if you're getting it from a legitimate source, then you can generally make a fair use argument. The complication that comes up there is if you're getting it from a database, there are probably also contract terms involved. So if you're getting it from a database, you're agreeing even if it's just in a like clicking I agree when you click download. You're probably agreeing to something that may put terms around what you're doing it, and those can be completely separate from copyright. So you could have something that is a fair use but is a breach of contract based on where you got it, which is a difficult issue. Okay, so let's keep going, and we'll come back to some of these questions at the end. So we've talked about Blanche v. Koons, we've talked about Rogers v. Koons. Now let's try applying it in another case. So this is a similar set of facts. I'm going to walk us through it. This case is actually pending in front of the Supreme Court right now. So they heard oral arguments on it in the fall. And there should be a Supreme Court opinion issued about this sometime in the spring. So this is something to keep an eye out for. And also, there are no right answers here. The Supreme Court has not yet decided. So let's weigh in on this one. Okay, so the facts here, we have another photographer, Lynn Goldsmith. She photographs celebrities. She does a lot of work in the music space. And in the early 80s, she does a photo shoot with the musician Prince and takes the photo over here on the left. So this photo, it's not published anywhere directly, but she ends up licensing it in 1984 to Vanity Fair for use in conjunction with an article about Prince. So Vanity Fair licenses the photo. They don't license it in order to publish it as is, though. They license it as an artist's reference for Andy Warhol to create a screen print illustration of it. So that's what we see over here. That's the one that ended up being published in the 1984 Vanity Fair. Everything discussed so far, not the subject of litigation, is everyone's agreed it's a licensed use. Vanity Fair has paid Goldsmith for this use. She's happy with that. They're happy with that. Warhol was happy with that. Everyone's good. Okay, so that's 1984. Jump forward to the present. Oh, sorry, a little bit more background. Goldsmith's photo is licensed to a Vanity Fair for an artist's reference. Andy Warhol does his Andy Warhol thing. He tends to not really create just one image. He creates series, and he creates not just the image that ended up being used in the Vanity Fair issue, but he created a whole series of Prince illustrations that all originate in some way with the Goldsmith image. So there are 14 silkscreen images, 2 pencil illustrations. The one gets used in Vanity Fair, the rest go into the Warhol archives, and the Andy Warhol Foundation, after Warhol's death, does in fact assert copyright in these images and licenses them for various uses. Okay, so jump forward to the present. 2016, Prince has died, and Vanity Fair is doing a commemorative edition, a whole issue about Prince. They remember this great article they had in 1984. They remember this image. They contact the Andy Warhol Foundation and say, we'd like to use this image again. Can we license it? The Andy Warhol Foundation says, yes, and actually we have these other 16 images. Do you want to choose a different one? Here are all these options. You can license them from us. Vanity Fair ends up choosing this one. And this is actually the first time that Goldsmith learns that there's more than the one image that was licensed in the 1984 version. And from her perspective, she was paid for that first one. She hasn't been paid for this one. Andy Warhol Foundation has been licensing these others this whole time. This feels uncompensated. The Andy Warhol Foundation says, this is what Andy Warhol does. This is a fair use. And it goes to litigation. Okay, so let's think this through. I have a series of polls for us. Let's think through the fair use analysis of these images. So actually I don't have a good side-by-side. We'll use this one as the side-by-side. So the first poll, let me launch this poll. Can you all see that? Okay. So for the first fair use factor, let's think about it. And I think the key thing to think about for this is this a transformative use of the Goldsmith photo? Interesting. I realize I'm the only one that can see the poll results. I'll show them to you in a moment. Okay, I think most people have weighed in. Speak now or forever hold your peace. Okay. I am going to share the results. You should be able to see that. So this is what y'all think. We seem to think that probably this is transformative, but there's a little bit of doubt. I think that's probably accurate with most of the commentary that's gone into this case. So that's the first factor. Now let's think about the second factor. So under the second factor, thinking just about the Goldsmith photo at this point, is this a highly creative photo? Is this something that copyright should protect? All right. Okay. So we do seem to think this is creative, mostly a little bit. There's some interesting things going on here. For the most part, photographs, there was a period in history when photographs were not established as necessarily being creative. People thought they capture the real world. How can that be creative? That's certainly not the way we think about it now. But and the way photographs are usually treated by the courts now is, you know, there's a lot of work that goes into it. There's a lot of decision making. Lynn Goldsmith is making decisions about the lighting. She's directing him where to look. Maybe she has a say in what clothes he's wearing, how he's wearing them, the position. So there are creative thoughts going into that. On the other hand, this is a pretty straightforward photo of Prince in some ways. He's looking at the camera. He's standing up there. It's most of his body. I could see this argued either way. And I didn't show you what the results were. Okay. Now you can see. Okay. Okay, so let's think about the third factor. Did Warhol use a reasonable amount of the photo? Okay, pretty much everyone has answered. We seem pretty set on this one. We think that this is reasonable. We'll see what one of the courts says in a minute. But yeah, he's not using the whole thing. He wants to use Prince's face. He's using Prince's face. If you believe he has a transformative purpose here, then that's probably within the realm of what's reasonable. Okay, and then the fourth factor. How does this affect the market for Goldsmith's photo? Okay, I'm going to end the poll. We seem to be much more divided on this one. I think that's right. I think this is a difficult question. There's there's also information that we might not necessarily have about this. But she is licensing the photo for artists' references. On the other hand, I don't know. Okay. Okay. So that's all the factors. Then let's wrap them all together. Overall, now you've thought about each of these. If you wrap it all together, what do you think? Fair use or not? All right. Last couple results trickling in. Okay, here we go. we are pretty divided, which makes sense because this is going to the Supreme Court. This is not an easy case. It's an interesting case, right? Is this over the line? Is this under the line? Is this right at the line? I think this is about. I think this response is about appropriate for where this poll has landed. Okay, so as I said, the Supreme Court is deliberating this, perhaps as we speak, probably not literally as we speak. But we will get a Supreme Court opinion about this probably in early summer. So this is something to keep an eye on. This is something to say to see what the Supreme Court says, see how it turns out, see if you were right. Let's see if you agree with the Supreme Court. What I can tell you is what the lower court said. So the way things get to the Supreme Court, they start at the lowest court, they get appealed. If you lose your appeal, you can appeal that to the Supreme Court, and then the Supreme Court can decide whether or not to take it. So the most recent opinion we have on this is from the Second Circuit. The Second Circuit concluded that this was not a fair use, so they ruled for Lynn Goldsmith, the plaintiff. This isn't the final decision. The Supreme Court may change this, but this is what the Second Circuit said. So they were not convinced that this is transformative. They said the overall purpose and function of the two works here is identical. They said the purpose here is to illustrate what Prince's face looks like, and both of these are doing that. They say it's much closer to being the same work in a different form, to being a new art that is using this as base materials. That is something that you can disagree with. That is something the Supreme Court may disagree with. We will find out. It is commercial, but they acknowledge the artistic value and the greater public interest of art existing, which is nice. I don't think that would be definitive either way in this case. And there also is a little bit of blurring between the first and the fourth factors here, but they're saying that there is a customary price for this. I think there's a strong aspect of Goldsmith got paid for the first one and then didn't get paid for any of the subsequent uses, and I think that's not doing Warhol any favors here. Second factor, nature of the copyrighted work. It is unpublished. That factors in here a little bit, that this image has been licensed for the reference use, but hasn't actually been published before. And it's a creative photo. The amount of the copying is interesting. There's an argument here that what Warhol is taking isn't actually Goldsmith's copyrightable work. So what he's taking here is what Prince's face looks like, which is not something that Lynn Goldsmith gets exclusive rights over through her copyright. She gets exclusive rights over this version of it. And the argument here is that that's not actually what Warhol is copying. He's extracted the factual information of what Prince's face looks like from this. Second Circuit disagrees with that argument. I think it's an interesting argument. Second Circuit disagrees. We'll see what the Supreme Court says. There's also an aspect of why is it this photo instead of a different photo? I think the fact that it was this photo actually argues in Goldsmith's favor. I think the court disagrees with me on this, but the fact that this photo captures this particular expression from Prince, maybe that factors in, maybe it doesn't. And then the impact on the potential market. There are different markets going on here, celebrity photography and fine art, but there is a customary licensing market for artist references that is being pretty blatantly disregarded here. That's not always determinative. Two Live Crew was denied a license, and then that was fair use anyway. But that's what the Second Circuit concludes here. Okay, I'm just gonna glance at the chat briefly. So the point in the chat about the decision leading artists to be more fearful of using pre-existing materials is a really good point. That is definitely one of the follow-on contingencies of these sorts of decisions is, what does this do to people who want to make fair uses in the future versus not. So there's a question, should we read into the Supreme Court agreeing to hear this case, meaning that they disagree with the lower courts? Generally not. There are a lot of reasons that the Supreme Court will agree to hear a case. Sometimes it's for that reason. More often it's because they want to clarify some aspect of the legal rule involved. So I think we're more likely to get an adjustment to how we think about transformative use out of this case, honestly, than we are to just say the test is completely good the way it is, but we think the Second Circuit applied it wrong. If the Supreme Court did that every time they thought a lower court got it wrong, they wouldn't have time to do anything else, is basically the argument there. Yeah. Okay. So that is that case. That is, and like I said, that is definitely one to keep an eye on. We shall see. Okay. Let's see, I'm looking at the time. Now for something completely different. I don't have a good transition between these cases. We started with a music case with the Roy Orbison case. We looked at a bunch of visual art cases. I don't want to give you the impression that all of fair use is visual art. Sometimes it's easy to get that impression, but there are other applications. And this is another big, important Supreme Court case that is good to be aware of. This is the Oracle v. Google case. This is a Supreme Court case decided in 2021. So it's pretty recent, and a lot of the commentary about Warhol is about how the Supreme Court is going to interpret Warhol in light of what they said in Oracle v. Google. So an overview of what this case is. So this is a case about the Android operating system and the Java programming language. And I'm going to issue a general disclaimer here that I'm not a programmer, and most of the judges and opinions that you will read about this are also not programmers. And so it's a little, if you are a programmer, I'm sorry. I'm going to do my best. Okay, so what's going on in this case is in the early 2000s, Google is trying to create a mobile operating system. It's a relatively new market at the time, and they're building Android. And the thing that they are trying to do is build an operating system that other people can play in. Basically, you're not going to have a successful mobile operating system market if you don't have apps. People aren't going to buy a phone if they can't get any apps for it. So they're trying to create something that people will either be able to easily port things into, or be able to easily write new things in. So they want it to be friendly to developers. They want it to be easy to use. So they start out in talks with Sun Microsystems, which was later bought by Oracle. That's why Oracle's in the case name here, about using Java. Java is a programming language. Lots of people are really familiar with Java. It's a natural fit for making this program accessible and usable for developers. That negotiation falls through. They end up not using Java, but they still want it to be familiar and accessible to people who are used to using Java. So what they do is they copy a couple of things, but not all of the things. They copy the structure of some of the packages, so kind of the organization of this, and then they copy what's called the declaring code. So they copy the declaring code, but not the implementing code. The declaring code is kind of the way this is where programmers are going to get mad at me. The declaring code is The way you ask the computer to do things, and then the implementing code is how the computer actually does it. So this example may be helpful, maybe not. In blue, we have the same declaring code with two different examples of implementing code. So you want the computer to tell you which of two numbers is bigger. That's kind of a basic thing that you might want to do in, and you don't want to have to code it yourself every single time. So you want to code this, but the computer can do that in different ways. So what they've done is they've copied the declaring code, they've copied the way that you ask the computer to do it, but then they've rewritten all the code for how the computer actually does it. This is a very simple example. It gets much more complicated than this, but that's kind of the basics of what they're doing here. So they've copied that. Oracle is not happy. Oracle says, you should pay us for that. Google says this is a fair use, and it goes all the way to the Supreme Court. And we have a question about patent, which is a good opportunity to clarify. So software and code is in a slightly odd place in terms of intellectual property, because it can be both patented and copyrighted. Patent generally involves more process. You have to actually apply for a patent. There's more that goes into it. Copyright you get automatically. So you do end up with a lot of copyright cases where you're in the copyright space because it wasn't patented. I'm not entirely sure that that's exactly what happened here, but at the Supreme Court level, at least, anything that wasn't copyright had already fallen out of this case. So this ends up being a pure copyright case. It can potentially be both. But yeah, so in the copyright space, is this a fair use? And so you are welcome to add your thoughts in the chat, but I think I'm going to jump to saying what the court said. So here's a summary of the court's argument. The court concludes that this is a fair use. So they side with Google. They say this is a fair use to copy the declaring code, but not the implementing code. Under the first factor, they say that this is transformative. They say kind of an interesting thing here, that actually the thing that is valuable here is not something that Oracle has any proprietary right to. So the thing that's valuable here is the fact that programmers know how to use Java, and Google is using just enough to, this gets into the third factor as well. They're using just enough to allow people to transfer those skills. And they consider that a transformative purpose. There's also some aspects of interoperability here. You imagine if the analogy I'll draw here is, imagine if every computer company used a different format of keyboard. It would be very, very difficult to ever do anything, because the way that you had to do things would be different. So there's some aspect of that would not be a pleasant world to live in, and we don't want to live in that world. So court says this is transformative. Under the second factor, there's an aspect in which there's an aspect in which the declaring code is considered this favors fair use, because this isn't the core of copyright. This isn't, I say this is more like a dictionary than a novel. This is more the functional aspects of it that are being copied rather than the creative expression. Okay. The amount of copying, there was some debate here over how you define this. It's a small percentage of the overall code. It's 0.4% of the total code, but it is almost all of the declaring code. So Oracle was, of course, arguing that they've used almost all of it. They've used all of the declaring code, and Google was arguing it's actually a very small percentage of the overall code, and it's suited to the transformative purpose. And the court agreed with that. The court said this is just what you need in order to allow that skill transfer. And then the impact on the markets, the court credits that these are different markets, that there's smartphone markets and desktop markets are different, and this is kind of transferring into a new realm. So the court concludes that this is a fair use. So that is that case. It's another one that's good to know about. It's a little overwhelming. It's a little hard to explain in 15 minutes. It's a complicated one, but I hope you agree that it is interesting. So I'm going to go through one more case because it's a different type of case, and I think it's good to see the variety. And we've had a couple of questions in the chat about educational uses and also AI and things like that. So I think this will be interesting to you based on some of the questions coming in. So the other cases, it's actually two cases, but similar fact patterns that I'm going to introduce to you are the Authors Guild v. Google and the Authors Guild v. HathiTrust. And these are basically text and data mining cases. So this is relevant to some academic research and interesting to think about in general. So what this is, so these are, so both of these are cases where there's a database of the full text of a large amount of books. So in the early 2000s, Google scanned a whole bunch of books from university libraries. Google got a copy of them, the libraries got a copy of them, the Google copies went into Google Books, the library copies went into a database called HathiTrust. You might be familiar with one or both of these. They have similar functionality. The way both work is you can search within, and you can it will give you it will tell you when your words appear in the book, but it won't let you read the book. That's the idea. So it will give you, a list of page numbers on which your search term appears. It will give you a list of books that your search term appears in. And in the Google Books case, it will also give you a snippet view. So it will give you a couple of lines of context around your search term. So this isn't with permission. The publishers of all these books say you've wholesale copied all of our books. And Google and HathiTrust say it's a fair use. We're not letting, it's different. We're not letting people read the books. We're letting them analyze the books. And one of the applications of this is frequency analysis. You can search for how common over time certain terms are, how common things are in different genres. So a lot of interesting research applications of this. So is it a fair use? This is what the court says about this. It is a fair use. Court says this is highly transformative because it is this different purpose. Analyzing the books in this way, returning search results from within the books is very different from the original purpose of being able to read a book with human eyes, being able to computationally access, research, index, all of these vast number of texts is a very different application than sitting down and reading a book. Nature of the copyrighted work doesn't factor in super heavily. It includes all types of books. Nonfiction helps, but doesn't factor in too much. The amount of copying, they're copying the entire book. That's one of the things that I think is interesting about these cases. They are copying the entirety of millions of books. There's a slightly different analysis in the two different cases here. In the Google Books case specifically, they conclude that it weighs slightly against. I think in the HathiTrust case, they conclude that it's neutral or doesn't matter. But the key thing here is you can copy the entirety of millions of books with a strong transformative purpose, which I think is counterintuitive to a lot of people. And then the impact on the potential market, they say that this also favors fair use. It's not serving as a market replacement for the books. So similar to what we were talking about in the first factor analysis, it's transformative. You're not doing this instead of reading books. You're doing this. You're doing this to do something different with the books. And to give you an idea of what the data behind that looks like, this is an example from Google Books. So you get the snippet view of here's where your search term appears in the book. And then you can also get the database version of, here are all of the instances of this word in the book, and that allows you to do some interesting data analysis on it. Okay, so I think we are low on time and people have questions, so I will not go through these examples. I will leave this up here on the screen. If you're an MIT student, faculty, or staff, I'm available to help you figure out your fair use applications. This is something that the libraries do. We can help you. We cannot give you legal advice. However, we can help you think through the issues involved in a project if you have something that is going to be relying heavily on fair use. So we can help you think through that. And I think from there, let's look at some questions. And here again, also, please sign up for upcoming sessions. There are a lot of them. They're very cool. But yeah, let's go to questions. I'm going to go ahead and stop sharing, actually. If I didn't answer a question that you had before, and you would like to re-up the request, go ahead. Go ahead, Maya.
Hi, thanks so much. That was very, very helpful, clarifying a lot of questions that we had. One thing that I see a lot common right now with the social media platforms, that there's a lot of people who use different media of art, for example, using different instruments or singing or painting or doing something like that, that, uses a certain song and they can make money out of it per the number of followers you have or so. They don't technically ask for permission. Is that considered copyright infringement? Because it's very common.
So it's a good question. It potentially could be a fair use. I think in actual practice, most social media platforms, I think this is true of TikTok. I think it's also generally true of YouTube. I'm not sure about others, but for many of those, it's actually licensed. So if you're getting the song from the platform itself, they are probably actually paying a fee to whoever the rights holder is for that song for your use. And they're recouping that through ads or whatever they're doing, but that is actually usually a paid use. It's certainly possible that many of those could be fair uses. The platform doesn't want to. The platform is paying for them anyway, generally because they don't want to have to litigate whether or not it's a fair use, and they don't want to have to administer whether or not it's a fair use on all of these individual bases. So it's an interesting space. Certainly, 10, 15 years ago, they were not all licensed. Whether or not they're a fair use, hopefully now you can think through the analysis and come to a conclusion. Many of them probably wouldn't be if it's just, here's the background music, I like this song. But if it's, I'm commenting on this song, I think this song says interesting things about this, I'm juxtaposing this song with something else, it could potentially be a fair use. Journalists copying photos from social media and using them in their articles. It's going to depend. So I know that's the answer that no one likes, but that is the truth of fair use. Is it's a holistic analysis. It's going to depend on how you're using it. Sometimes it's going to be a fair use, and sometimes it's not. There is more of a norm of paying for that than not, whether that's because it's not a fair use or just because it's easier to pay for it and we're afraid of litigation is up for debate. But it's going to depend on the type of use. And I should say, for all of these answers, I cannot give you legal advice. Don't get your legal advice from webinars, but we can think about interesting questions. So the Gerald Ford case is an interesting one. So the summary of that for folks is a magazine got a hold of a copy of an early version of Gerald Ford's autobiography. Gerald Ford was the president who pardoned Nixon. Most of the reason that people were interested in his autobiography was his explanation for why he published Nixon. That's me editorializing a little bit, I suppose, but that was that was certainly a high point of interest in the book, and The Nation, the magazine, published published basically just that excerpt. They published that part that people were most interested in more or less its entirety before the book had actually come out, and that was determined to not be a fair use. It had a big market impact on the book, arguably, and it was determined to not be transformative. So that is a good example, I suppose, for in the journalism context. It was certainly newsworthy. There was an accepted licensing market that was ignored, and it was determined to not be a fair use. Okay, students publishing their own work as theses, but also in journals. That's actually something that I help people with directly all the time. So if the student is creating the thing, then the student is the copyright holder of the work, with a caveat that under MIT policy, sometimes MIT is the copyright holder of the thesis. So regardless of whether the student is the copyright holder or MIT is the copyright holder, we're not going to sue MIT students for reusing their stuff, but the journal publisher may want documentation of that, right? So if you are in the situation of needing documentation of that, you can certainly get in contact with the libraries, and we can help facilitate that. And the fair use case, you can reuse something verbatim if you're using it in a transformative way. I don't want to give the impression that it's not fair use. It could also still be fair use. But if you need documentation of permission, you can get it as well. Okay. So there are a lot of great questions. I can't answer them all. There's a question about how much of a book or article you can distribute to students. It's a great question. It's one of those that I can't give you a short answer to. So the case for this is the Georgia State University case, which I can't find the link to that immediately, but there was a lot of litigation over how much you could give to students, and what the court said, which is frustrating to many librarians, is you have to do a fair use analysis for every single one. So there are different shortcuts for it that you can use. You feel free to email me if you're an MIT person, and we can talk about it a little bit more. There are norms that various places apply to that. But the official answer of the court is no shortcuts. Fair use has to be a case-by-case analysis. So you'd want to be thinking about, should the students be buying this book instead of receiving this course pack? Are you using enough of this book that really the students should be bearing that cost, which is a difficult thing to ask students to do. But if it's a small amount, that can be reasonable in a lot of cases as well. Okay, so the slides, I will repost the link to those. Those are available for you. Let me grab that link. And the recording for this will be available afterward. There's the link to the slides. Okay. Well, I think we can. I will hang out here for another 5 minutes if folks have questions, but I also will let you get on with the rest of your day. And thank you for coming. And have a good 2023.
Thank you, Katie.
So the Georgia State, yeah, I do have a minute. I can find that link for you. It's about course reserves, so it's about it is about posting things to a site like Canvas or something like that, and how much of that is permissible, basically. The gist is the frustrating gist is basically that you do have to do a case-by-case analysis of each time, and it's you know, what is your transformative purpose in assigning this reading? You have to think about, you know, are you commenting on this reading, and then also, is it relevant in the is the amount such that it makes sense to not require students to purchase the whole thing. So if you're doing it, if you're putting 3/4 of a book up on course reserves, then probably that should be an assigned text. If you're putting one chapter from 7 different books up on course reserves, then that's reasonable to, that could be more reasonable to do. And different places have different rules of thumb, but it's a complicated problem to solve. Okay, well, I'm going to sign off. Thank you all for coming again, and see you later.